Arguably, these enhanced advocacy efforts are a fulfillment of the organization's mission. There you go. It's like we created a bunch of new clients for you. Ridiculous. With full rights and access to our resources, just become a citizen. Hello? It's not that complicated. There's a whole process for it already. You don't need to exist. And the court declines to engage in such acts of personal aggrandizement. Wow. Mandatory alien registration now in effect. This order came down from Judge Trevor McFadden, a Trump appointee who we were not real happy with yesterday. But we're happy with this order because what he has found is that this group called Coalition for Humane Immigrant Rights, oh, what a bunch of really nice people, true heroes and civil servants for treating immigrants humanely. Okay, well, they sued Homeland Security and they said, hey, Trump's memo that says that if you're here illegally, you have to register or it's going to be a crime and you have to carry some form of identification with you or you're going to be in trouble. They sued to stop that. Well, guess what? Judge said, you got no standing. Here's what happened here. It says from the judge, he says, look, all right, background. Bunch of advocacy organization like the Humane Immigrant Rights Coalition, HIRC, we'll call it the HIRC, Humane Immigrant Rights Coalition, serving immigrant communities, bring a motion to stay, right? Trump issued a final rule, came out from Homeland. Thank you, Kristi Noem. So then they moved for a preliminary injunction and they are challenging a new rule. They say from Trump, he passed this, that previously unregistered aliens must complete to comply with statutory registration requirements, saying that there is a form that was passed, fill out the form to get registered or else. They sued saying you can't use the form's illegal. We love illegals in our country. So the so-called immigrant groups allege that the rule redirects previously unregistered aliens also to do the following: provide biographic and biometric info. So we're scanning your fingerprints, we're taking photos, we're doing all of the things. And you also have to carry proof of registration as well, since you're in our country illegally. But the judge says, guess what? They're suing on this. And unfortunately, the court cannot reach the merits of these allegations brought by the immigrants, saying they have failed to show that they even have a substantial likelihood of standing. Womp womp. As organizations, many of their harms are just too speculative. They have failed to show that a rule will erode their core mission, nor do they derive standing from their members. They have not shown that any individual member possesses a concrete harm that's cognizable by an Article 3 court. So that's a big victory there for Trump. And stuff like this, right? Even if Trump, you might say, well, how are they going to enforce this? They're just going to go around and stop people on the streets and say, are you illegal? Maybe. But in addition to that, stuff like this, I think, will cause people who are already on the fence of self-deporting to self-deport. And they can use the app to do that now. It was Uber into America, Uber invasion. Now it is Uber afuera. Uber afuera. It's a nice ride. Get yours today, courtesy of the federal government. The story behind this case begins in 1940, writes the judge, when Congress enacted the Smith Act, also known as the Alien Registration Act. Now, the act instructed aliens, except foreign officials, who were present in the United States, 14 years or older, who remain in the country for at least 30 days to register and to be fingerprinted at a local post office. And so remember that when they come out and they're like, Trump is forcing everybody to get on a list. What? They did in the 1940s. Talk to FDR about that, your lover boy. Now, upon registration, the alien was issued a form AR3 and the registration receipt that it can self-confirm, no immigration status or benefit, right? You're just registering to register. Thanks. Now, over the decades, the administrative state would dilute these statutory requirements by regulation. Okay, and this is the judge writing this, which is great. Trevor McFadden, we appreciate that language. Thank you. It is an administrative state, and they do dilute things down that are passed in order to secure the country. In 1944, the Immigration and Naturalization Service eliminated the division responsible for universal registration, and shifted registration from post offices to ports of entry and immigration offices. Interesting, right? So how many people are going to go to ports of entry versus a post office? You're already inland in America. You're not going to go to immigration. Post office is much more accessible than a port of entry because there's a lot more of them. And in the 1950s, INS suspended the use of that form. Instead, INS subbed in pre-existing immigration forms that were only available to aliens with legal immigration status, like Form I-151 for lawful permanent residents and Form I-94 for aliens with a record of lawful entry. Wow. So it just gets watered down, right? There's one form that is for unlawful, illegal people to use. And they just kind of use that form. If we have a separate form, then we kind of know who those people are. So why don't we just make them use the same form as someone who actually has legal status? That's our stupid administrative state. So through regulations, aliens who had entered the country illegally were effectively exempt from the statutory registration requirements since there was not a process by which they could register. Like the law was on the book, but there's no form. They just took the form away. Now this is the judge writing, and regulatory dissonance continued with the passage of the Immigration Immigration and Nationality Act, 1952. Now, the statute supplanted the Smith Act, overrode that one, but it incorporated its same registration mandates, adopted that. Now, the statute requires that visa applicants go through the visa process, and for those not registered this way, INA includes provisions for registration and fingerprinting of all aliens over the age of 14 who are at least here 30 days, and similarly makes their parents register. It also adds on to the Smith Act by adding a requirement saying aliens age 18 and older must carry registration at all times. And more, the INA makes it a crime, to willfully fail to register or to be fingerprinted, punishable by up to 6 months of prison. Now, the implementing regulations are a bit different. And so we talk about this a lot here, and this, I think, is going to be illustrative. So watch how this works. This is how our snaky, sneaky government works. So Congress will pass a statute. You'll see it codified in U.S. code. See this USC, U.S. code, in these various sections. Congress is not really good at implementing things. They're not really good at much of anything. So they write statutes and they think, well, lawyers write these things and they supposedly wordsmith them out and think them through. We learned that they don't. That's why we have a lot of litigation about them. But they pass a bill, law goes into effect, but then in order to implement the law, they have to create regulations. So you see these federal regulations. We refer to them here as the Code of Federal Regulations. You often see them cited as CFR, and the CFR is the implementation of the law. And then what happens there is in the regs, everything changes. They deviate away from the actual law, just like this. The implementation rules are different. Now, they first provide that only the available registration forms for aliens who were not lawful permanent residents was an I-94. Now, over the years, as Congress created additional forms, the INS added some of these forms as proxies for the registration document that was demanded by law. Okay, so they just change it like they're not following the law administratively via regs. Well, I mean, we can't. Congress wouldn't have known that we couldn't do it this way, so we have to do it this way, and that's pretty much in compliance with the law, isn't it? Lawyer, they send a memo. Yeah, it is in compliance because this. So it's like different from the law, sometimes 180 degrees different, but they say it's the same. But still, this means, says the judge, that the only aliens who registered are those with legal status. The regulations do not include a non-discretionary registration form for an alien who entered illegally. They don't want to count them. So then in 1960, the INS removed the carry requirement from the Code of Federal Regulations entirely. Now, this scheme persisted for decades. This is not democracy, by the way. Okay, this is not representation. The founding fathers were very unhappy when they did crap like this to them. They threw a bunch of tea into the ocean, and it was well-deserved because they were being exploited by supposedly their own government and their own people. That's exactly what's happening here. Okay, it's a scheme. It's not the law. They violated the law, but there's regulations and everybody does it. It goes on for decades. But in January 2025, that crap came to an end. President Trump switched course. He instructed Homeland, in coordination with Pam Bondi and Secretary of State Rubio, to immediately announce and publicize information about the legal obligation of all previously unregistered aliens to comply with the requirements of registration and to ensure that all previously unregistered aliens in the United States do. And they're going to be treated as a civil and criminal enforcement priority. That is the executive order in compliance with the law. Now, last month, Homeland published an interim final rule, creating a new online general registration form, a form that should have existed for decades, but didn't. It's called the G325R. Interesting, numbers, but okay. The interim final rule allows for a submitting of a form under statute, and plaintiffs argue this is a broadening of the requirement. And you can't do this. They say you created a new form. You can't do that. The law doesn't say you can do that. But before any of that could happen, before the rule could go into effect today, the date of this recording, on April 11, 2025, they sued to stop it from happening. Now, before that could happen, they sued. They sought a stay of that date. There are a handful of these nonprofit organizations called Coalition for Humane Immigrant Rights, called a CHRLA, the United Farm Workers of America, and the Make the Road New York, and CASA. Yeah, all of these groups. Now, these organizations are member-based. They comprise many aliens, illegals, and citizens who belong to mixed status families. Now, they allege that the interim final rule, as they sue, was issued in violation of the APA. You can't do this. You can't make these changes. They say this is a new legislative rule. We need opportunity to know about it. It's arbitrary and capricious and more. But Trump responded. He says, look, no way. You guys are going to lose. By the way, you don't even have standing to sue here. So get out of court. And even if this court had jurisdiction, since they don't have standing, Judge Trevor, you can't hear this. The government insists, Trump, that the interim final rule is a procedural rule. So we're just making some procedural changes. We're not changing anything substantively. This has been in the book since the 1940s. The fact that every other moron president hasn't been able to enforce the law and execute the law, which is their constitutional duty, that's their problem. We're just procedurally changing things. You're not entitled to any notice at all. And the government says it's not arbitrary and capricious. That's a law. So the court, Judge Trevor, held motions earlier this week, and the motion is now right for a disposition. So we'll get a ruling. Judge says, look, a preliminary injunction is an extraordinary and drastic remedy remedy. We've seen many of them here over the last several months. Now, the movement faces a high bar of success, so these illegal representatives got to prove their case. Now, they also have to show that they're going to suffer irreparable harm. This is not passed. We got to balance the equities, talk about public interest. But here's what happened. Now, they have not shown, these illegal groups have not shown that they are likely to succeed on the merits. They have failed to demonstrate that they have standing to bring this lawsuit. Standing is a bedrock constitutional requirement. Hello? It requires that a plaintiff possess a personal stake in the outcome, which helps to ensure that the court can decide specific rights in the case. Now, standing doctrine serves to protect the autonomy of those who are most directly affected so that they can challenge it. You got to actually have a case if you're coming to court. And it ensures that the framers have their concept of a limited court system vindicated, citing John Roberts there. Now, to establish standing, a plaintiff must show that it has suffered or likely will suffer an actual injury and that the courts can do something about it. A couple ways they can do this. They can be an actual organizational plaintiff and have organizational standing. In other words, an organization can represent its members. So they say, let's start there. Well, if you want to demonstrate that you have suffered an injury, in fact, Coalition for Humane Immigrants, it must show that it's more than a frustration of its purpose that's happening. It's got to be something bigger. Mere hindrance to a nonprofit's mission, just because your mission is not the abstract concern that gives you standing. What? Get out of here. Everybody would be suing everybody for anything. Instead, for an organization to have standing, it must have suffered a concrete and demonstrable injury to its activities. That is, Trump's conduct must have, quote, perceptively impaired the organization's ability to actually provide services, and they must have used its resources to counteract that harm. But it is not enough that these immigrant groups merely divert its resources in response to the actions. It's got to be more than just operational costs. Instead, they must show that they had to expend resources in a manner that keeps it in alignment with its true purpose. The judge says, I'll give you an example of this. There was one organization in another case where they said that their mission was to guarantee safe, wholesome food. They sued, saying, well, this new system harms us, and we're going to have to increase this and do all of these other things. And they said, sorry, you lack standing. The new system is too abstract, like government changes things. You have to change as well. There was also PETA. Oh, gosh. I think I'll have some ribs tonight. Says, thankfully, PETA challenged, the government refused to apply the act. And they said, well, organizations whose activities have been impeded here have to have more. And this case looks less like the organizational impediment and more like the other case. Out of the plaintiffs, only Chirla claims organizational standing, but there's even a few issues with their claim. Now, they're suing the humane immigrant rights, very humane people, such heroes, say that they're highly speculative, their injuries that they're claiming. These are prospective fears about what might happen when the rule takes effect. They say, well, we expect, there you go, there's that language, we expect thousands of individuals are likely, hasn't happened, to reach out for assistance and advice with the new registration process. And we're going to have so many illegals calling us that we have to stop you because it's going to be a strain on our staff and budget. Like, America can't govern itself because illegal alien facilitation organizations are going to be busy with enforcement. So we can't govern our own country. That's their position, not what the judge held. It also expresses anxiety that the anticipated demand for legal advice and assistance may cause it to fail to meet certain grant conditions and thus face withheld disbursements, right? So we're not going to get our money either. As the Supreme Court has said before in 1998 in Clinton case, Chirlas, the illegal groups, and their feared harms have yet to come to fruition, and they may never well manifest at all. It's just speculative. They rely on the choices of an unspecified volume of intervening third parties, the illegal aliens, who may or may not demand an indefinite amount of your resources. Yeah, they might just go back or just register. Just register the form, go about their day, or go home. They don't necessarily need to call you guys. When the existence of one or more essential elements of standing depends on the unfettered choices of independent actors that are not in front of the court, it's hard to establish standing there because it's too speculative. So Chirla might not be so taxed by a swell of inquiries that they lose funding. There are no numbers before the court, no evidence that they've given to us to suggest that, nor is there any evidence from grant providers that any termination looms. So without any facts, the court has just uncorroborated fear. But Article 3 requires more than just maybes. It demands actual or imminent harm, and they haven't done that here. And more, Chirla cannot demonstrate that the interim final rule has perceptibly impaired its mission at all. There is certainly no claim that the government is blocking Chirla from claiming or doing its mission. They can do whatever they're doing before. Rather, they insist, they say, well, our community members are already calling our hotline, and they already have questions about this. And now we're going to have to reallocate our times. So how dare these nonprofits actually have to do something and serve their constituency when our country enforces its laws that have been on the books for 60 years? But mere self-serving observations that an organization will have to increase the resources it's spending is not enough enough for standing. So are broad claims. They say, well, we've diverted our resources to deal with all of our aliens. When a nonprofit merely expands its operations to address increased demands from its communities, that's not called tampering. That's giving you more resources. That's giving you more demand. Arguably, these enhanced advocacy efforts are a fulfillment of the organization's mission. There you go. It's like we created a bunch of new clients for you. In other words, the final rule has not impeded them, it's fueled them. It needs your work. Indeed, the expenditures that Chirla has made have not kept it from pursuing its purpose. In fact, it's contributed to its purpose. Now they can get out there and just, scream, we're fighting for the humane treatment of illegals against Trump. AOC can go cry on a fence again. Chirla's own descriptions of its pursuits only undergird this conclusion, right? They're patting themselves on the back right now. They say, go on their website. Their mission says that we're ensuring immigrant communities are fully integrated with our society with full rights and access to resources. Get out. If they're illegals, we don't want them integrated into our communities. Okay, that's the point. Ridiculous. With full rights and access to our resources, just become a citizen. Hello? It's not that complicated. There's a whole process for it already. You don't need to exist. In furtherance of its mission, Chirla handles the full spectrum of needs of those primarily residing within low-income immigrant communities, yes. And one of Chirla's primary programs is a hotline where individuals, including members, clients, and community members, can call with questions. Great. Given Chirla's deep community ties and longstanding legal service programs, Chirla is often a first point of contact for individuals seeking information. Great. So the judge says, well, it would be odd if Chirla could assert that its core services have been impaired by using these very services that people want to use. Sure, the rule may have caused them to rearrange some labor and resources to meet the additional demand, but that's not a concrete injury. Just because shift in government policy demands shifts in internal operations, if that were the case, an organization could claim injury in fact nearly any time. Anytime there's a change in the law relevant to its mission, everyone can sue. This cannot be the law, says the judge, obviously. And indeed, it is not. Organizations only suffer concrete injury if a challenged government action has made their advocacy efforts more difficult than normal. And Chirla has not shown that here. So then we have to talk about associational standing. Can they sue on behalf of the illegals? 3 questions. Would its members otherwise have standing to sue in their own right? So could the illegal sue on their own? Second, the interest it seeks to protect are germane to its organization's purpose. And third, neither the claim asserted nor the relief requested requires the individuals in the lawsuit, right? So the organization can adequately represent them without them even being here. They say, nope, they stumble at the first step. They failed to show that any of their individual members would also independently have standing to challenge the rule also. It's a law. Associational standing also fails for 2 independent reasons. One, the only allegations of any harm to individuals are in the form of pseudo-anonymous hearsay. So little declarations from whomever, no one knows who they are. That's great. Anybody can make up fairy tales. That is, the organizations are describing the harms of their members while they use false names for them. Well, we can't identify them because they'll come under scrutiny and scorn from Americans, like Rob. Says the court has no sworn testimony from members themselves. Moreover, these pseudo-anonymous reports are contained in affidavits submitted by the organizations, which themselves are hearsay. So this means that all the court has to go on is hearsay within hearsay. Well, that's a racist thing to say. You don't trust them? While a preliminary injunction is customarily granted on the basis of other things, layered hearsay innately lacks credibility. Well done, Judge Trevor McFadden, as it only exacerbates the pre-existing veracity issues inherent in regular hearsay. Now, the problem becomes even more pronounced when it's under a pseudonym by illegals, leaving the court and the defense completely unable to verify anything. Isn't that convenient? The court is therefore very wary of this evidence. Yeah. More importantly, this nameless double hearsay is going towards the court's jurisdiction, and the court must abide by its unflagging obligation to police its own constitutional bounds. Now, asserting the authority of Article 3 based on nameless double hearsay strikes the court as an exercise in judicial arrogation, and the court declines to engage in such acts of personal aggrandizement. Wow. All right, Judge Trevor, I'm sorry I was so mean to you yesterday. I was upset. I was emotional, but I appreciate what you've done here. But even if the court were to credit the double hearsay and believe it, the plaintiffs have failed to articulate a viable theory of associational standing anyways. Plaintiffs' primary conception of their members' injury is that they are directly regulated. That is, they insist that their members have suffering and injury in fact because they have to go fill out a form. They have to provide biometrics. They have to carry proof of registration, as the law says. They could face a harm because they could get arrested, but they have failed to show that the mere requirement to abide by the law, even if true that the accompanying regulation flouted procedural requirements when enacted, that constitutes a concrete injury. Otherwise, anybody would sue anytime they don't like a law. If you have a problem with a law, there's a remedy for that. You got to go engage in politics and convince enough people to change the law. That's the remedy. You don't get to sue the government. That's why we have voting. Plaintiffs' briefing and their oral argument had no claim that such a close relationship would allow a basis for a lawsuit saying saying they didn't make the argument that gives us the right to sue because we're unhappy with the law. They said that's not what they said exactly. But as made clear, you must identify a close historical or common law analog for your injury. Like, what is the injury? What is the tangible harm? It's got to be something like physical or monetary harm. Various intangible harms can also be concrete, but you got to give us something here. Now, they have not shown how merely being subject to a regulation without incurring any other injury or something is a harm. Like, it's the law, you got to do it. If you want to drive a car, you got to go get license and insurance and register your vehicle, right? You got to go do those things. Pretty basic stuff. They have not attempted to analyze, and if you're driving on a suspended license, that's a crime. They have not attempted to analogize their members' predicament to harms traditionally cognizable in an American court. So, like, there's no precedent for prior claims like this, nor does a historical analog so readily come to mind that an explanation would be unnecessary. They point to this other case to argue that subjection to new regulation requirements can be an injury, but that reliance is misplaced now. First, this case was decided before the sea change in TransUnion imparted upon the standing doctrine, so a lot changed after that, and thus the court doesn't have any occasion to consider this, whether this is sufficiently analogous. But also, the case is distinguishable. It's just not even the same. Now, it's true that courts have occasionally found standing when a plaintiff brings a challenge, but in those cases, the plaintiffs also had to show the law was hammering a constitutionally protected right? If the law goes against the Constitution, you can challenge the law, obviously, because your constitutional rights are supreme to that congressional statute. But if that is not the case, then the method of changing the law is by voting. Now, these people are not citizens, right? And they don't have a say in that occasion, which is why they're so upset and suing everywhere. But they don't have standing for it. Now, in other words, standing in the risk of prosecution cases requires that a plaintiff to show that he has been put in an intolerable choice, okay? One or the other. You are either engaging in your constitutional rights or you're being penalized under the law. But that's not what's happening here. Saying the plaintiffs here have not shown that their members have been trapped in this paradox. If there are costly compliance measures, plaintiffs are mum as to their amount. Well, how much is it going to cost to go get and fill out a form? Not much. Nor have plaintiffs shown that the final rule is penalizing constitutionally protected conduct. They say, well, it's going to force our members to reveal that they entered the United States illegally, and it could be a misdemeanor under 8 U.S. Code 1325. And by the way, that's another thing that you see a lot. I think I saw Abby Phillips on CNN saying, it's just a civil offense. It's not a crime. Because we always say, well, their response is they never committed a crime. We say, yeah, they did by breaking and entering into our country. They say, no, it's a civil offense. And I think they're conflating like overstaying a visa with illegally entering the country. 8 U.S. Code 1325, a federal criminal misdemeanor, entering the U.S. without inspection, illegal. According to plaintiffs, this admission is a violation of their Fifth Amendment rights against self-incrimination. Now, indeed, a major thrust of their motion relates to Fifth Amendment implications as well. But this line of attack fails factually and legally. First of all, factually, because plaintiffs have failed to demonstrate that any of their members would actually be subject to criminal prosecution based on their form, right? It's just a form. A charge for entry without inspection usually carries a statute of limitations of 5 years, which begins to run once they enter the United States. Then it expires, okay? So they race in here, and as long as they can stick around for 5 years, well, they don't have to worry about that federal charge. Nice. Nearly all of the plaintiff members have been residing in the U.S. for longer than 5 years. So you can't come in here and say, well, if they register now, then they'll be subjecting themselves to criminal prosecution, because they won't. The law's expired. Any plaintiffs conceded that their members do not have other crimes to report on as well. Thus, so for nearly all plaintiffs here, the Fifth Amendment right is not even implicated because they've been here illegally for more than 5 years. Incredible. Now, there is one possible exception. Her name is Ursula. Fake name, obviously, but probably representative. A Churla member. Ursula entered the U.S. without inspection in 2023. Are they picking like the most disgusting Disney characters that they could possibly find to give us a representation of who these people are? Entered the U.S. without inspection in 2023 as an unaccompanied minor when she was 17. All right, let's feel a little bit bad about that, but still, perhaps she could be subject to prosecution for an illegal entry misdemeanor, maybe because she was a minor. Yet plaintiffs waffled on whether Ursula would be subject to criminal prosecution as an adult or as a juvenile. But does the government even prosecute juveniles for misdemeanor illegal reentry? Because the burden is on the plaintiffs to establish their standing, the court will not go digging into the intricacies of immigration law to deduce whether one member out of dozens could assert a potential infringement on her Fifth Amendment right. But even if Ursula could be prosecuted, her Fifth Amendment claim would fail as a matter of law. Now, a plaintiff can rest her standing on a violation of her right against self-incrimination in two cases. First, where the plaintiff remains silent, asserts the Fifth Amendment right, and then is subjected to some sanction or penalty. She clearly can assert a Fifth Amendment claim. I asserted my claim. I've been damaged as a result of asserting that claim, and now I can file a claim because my constitutional rights have been violated. And second, where a plaintiff has refrained from invoking the privilege, given an incriminating statement, and then seeks to bar the use of that statement later, a justiciable claim will surely exist, meaning she could sue for that. Now, out of these two circumstances, she's not suffered a violation of her right. A violation of a constitutional right occurs only if one has been compelled to be a witness against himself in a criminal case. In other words, a Fifth Amendment self-incrimination claim is not ripe until a claim of the privilege is actually made. And no one is claiming that of her. No one's saying, come in and tell us about how you got here and tell us who brought you here and reveal, more about your story and who else is involved. No one's saying anything like that. So she doesn't have to talk. Plaintiffs do not allege that any of their members have actually invoked their Fifth Amendment right and been rebuffed, saying you have to talk or else. Nor do plaintiffs even allege that an invocation of the right against self-incrimination on Form G325R would even lead to sanctions. They can't show that at all. At this point, any claim that the members make saying a risk of violation of their right are just speculative and they're totally premature. And so the reason is apparent. The Fifth Amendment does not forbid the government from asking questions. They can ask questions. And it does not forbid the government from taking the answers. If you voluntarily give the answers, then you did that. Now that leaves the assertions, the new form chills their protected speech. They say, well, CASA and illegal members fear that the new registration process, which requires them to report their organization, will cause immigration authorities to target them based on their forms. But allegations of subjective chill are not adequate to confer standing. That's not enough. They must allege an imminent harm. Here, all they say is their members have engaged in self-censorship because they have a conjectural fear that they may be targeted. In other words, they say, well, it's their own subjective apprehension. If they're freaked out about this, they can go home. What they have not done is offered any evidence of a credible threat of prosecution for their speech, not for their speech. Nothing they're saying is going to lead to a penalty for them. It's the fact that they're here illegally. Under controlling law, that is what they had to do, is have some statute that made speech illegal. Government can ask questions. They can fill out their forms. In some, they're not going to win because they have no substantial likelihood of standing. And so their motion for a stay and preliminary injunction is accordingly denied. So ordered by Trevor McFadden, who we're happy with now. Again, all of a sudden, very difficult relationship to be in with us here. Now, Hakeem Jeffries came out and he had a little bit of a statement here. And here's what he was saying about the border. And this was a curious one because here's Hakeem, and Hakeem Jeffries sounds like he's going to want to secure the border.
Republicans are proposing new spending for border security funding in this forthcoming budget bill. Is that something that your conference will support, that sort of security investment?
We have to look at the particulars. We believe that we need to secure the border, make sure that it is safe and strong, that the rule of law, consistent with America as a country of a nation of laws, is fully and completely implemented at the border. We believe we have a broken immigration system and we need to fix it in a comprehensive and in a bipartisan way. And we also believe that we must always defend dreamers, farm workers, and law-abiding immigrant families and protect them from
what does that mean?
Overreach by the Trump administration. Those are the principles that we have consistently articulated publicly and privately to our Republican colleagues as it relates to finding some common ground on the immigration issue.
Wow. So that's Hakeem Jeffries. And he is speaking in a language that sounds like he's wanting to solve this border problem. Don't know what got into his tea. Might be the polls. So that was Hakeem Jeffries. Oh, yes. The SAVE Act bill also got passed yesterday. So almost every single Democrat just voted against the bill to require proof of U.S. citizenship before registering to vote in federal elections. So they just want more and more of this. Look at that. 208 Democrats voted against it because they love the illegals. They don't want people registering, but the SAVE Act is going to change that, saying this administration from Trump, he'll sign it as long as the Senate gets it to his desk. The SAVE Act, Safeguard American Voter Eligibility Act. The bill would enforce a principle long enshrined in our laws, writes the Trump administration. Only citizens may vote, while federal law explicitly prohibits foreign nationals from registering to vote or voting in federal elections. Loopholes and deficiencies in the National Voting Registration Act have allowed non-citizens to illegally register to vote and hindered states' ability to stop it. We covered this a lot in both last elections. Though amendments to the NVRA and through them, the SAVE Act would end the lawlessness by requiring states to obtain proof of U.S. citizenship before registering an individual to vote in federal elections, while establishing safeguards to ensure every citizen is able to register. The bill would also require states to regularly remove non-citizens from their existing voter rolls and provide the tools necessary to do so. Even more fundamental than enforcement of federal law, the bill will increase the public's confidence in the fairness of our elections and the validity of their results. If H.R. 22 is presented to Trump in the current form, his advisors would recommend that he sign it into law. And we hope he does. So it's off to the Senate. Hopefully they get it done and they get it on his desk.